Seems like everybody wants me to talk about two things: the Mexican Padilla arrest, or turning himself in, and the complaint form, or not the criminal, civil complaint. There we go. Words, how to use them. There's not really a whole lot to say, believe it or not, about the Mexican Padilla. Padilla. Not much to say about it. The 17.09 says that provided that whenever during the course of the action the judge or magistrate in whose court such action is pending finds the bond is defective, excessive, or insufficient in amount, or that sureties, if any, are not acceptable, or for other good and sufficient cause, such judge or magistrate may, either in term time or in vacation, order the accused to be rearrested and require the accused to give another bond in such amount as the judge or magistrate may deem proper. When such bond is given and approved, the defendant shall be released from custody. Ta-da! And then 17.15, the bail shall be sufficiently high to give reasonable assurance that the undertaking will be complied with. Basically, Mr. Padilla was being stupid. If you are facing charges for harassing city officials in Leon Valley, Texas, the prudent person would stay the F out of Leon Valley, Texas. I don't believe that Mr. Padilla lives there, nor do I believe he works there. In fact, I don't believe he will be working anywhere soon if he can't go to work due to his frequent incarcerations. I don't know what to say. If you can't stop from getting arrested, then yes, they will increase your bail to try to persuade you to take a more prudent course of action. And no, it's not that the cops are bad or evil. I have managed to go 4.5 decades without being arrested once. I can understand maybe once being arrested for no reason, like the police just mistake you for the actual perpetrator or something like that. I can understand that. Maybe even twice. But what is it, 4, 5 times? 6? In like a month or 2 months? I mean, it's a tad bit excessive, Mr. Padilla. Maybe you want to slow your roll until you get some of them charges, I don't know, squared away. Christ on a cracker. Yeah, it's all everybody else's fault, though, Mr. Padilla. Yep. Now on to the complaint. The complaint's weird. The form's a little weird. I do know that Texas is big on e-filing, so normally up in the upper left-hand corner, you would have like the name and law firm name and phone numbers and contact information for the attorney. And it would state who the attorney was for, like attorney for plaintiffs or something like that. Something identifying them. Normally you'd see it on lined paper. Normally. Like a 28-point lined paper. So that's kind of weird. But again, I'm not familiar with Texas or Fifth Circuit rules or anything like that. Normally, you would have like what you'd say like complaint page 2. Normally. Normally, you wouldn't list Mr. Springer as a resident of the city of Westerville, Ohio. It's just, there's just a lot of like weird things. Like, so Mark Brown is here and after known as Brown. David Bailey is here and after known as David Bailey. They just gave up. I don't know. This one's really weird. Plaintiff Russell Zinter is Russell, but then later on they call him Zinter. I don't know. Why would they even leak this? Like, you wouldn't want to necessarily taint your jury pool. Because here's the issue. Here's the fun thing. Anybody who's going to be on that jury pool, they're going to ask all sorts of things about like what you know about it. And if the complaint's already out there, you've already had a chance to read the complaint, that might disqualify you from the jury pool. And who's going to read this complaint? Is it the people who are sympathetic to the plaintiffs, or the people who are sympathetic to the cops? Who do you think's going to read this complaint? It's just so many levels of weird. I just don't understand it. I just don't understand it. So we get the mention of their attorneys in this paragraph right here. And it's Burgess, through their attorneys, Burgess and Mr. Burgess. Are there two Mr. Burgesses? It's weird. Who's Solomon Radner? He's not licensed to practice law in Texas. The Ex-Colo Law PLLC is also not a Texas law firm. It's a little bit weird. It's in Michigan, and Mr. Radner is also from Michigan. 1-800 law firm, Detroit metro area, Ex-Colo Law. Yeah. Radner Legal Service Attorneys. There's our Mr. Radner. So he's got two outside attorneys who will work with him. Of counsel means they're not like associates, but they'll take on some of his clients and cases if he needs them to. It's got to be his dad. That's the dad. That's the son. Cool. Yeah, so I'm not entirely sure. I'm not sure what's going on there. He could be acting, and I'm going to say this completely wrong, pro hac vice. I know it's like pro hac wika. It looks like pro hac vice, so I say pro hac vice. If you don't like it, tough titty, said the kitty when the milk went dry. So I don't know what's going on here. There's no first name for Mr. Burgess. Burgess. I don't know. Let's see if there's anything down here. He's got a Michigan number. Wait, what? Who's Brandon Grable? Of the Grable Law? Of the Grable Law firm? Wait. This is actually the first time I saw this. I'm not familiar with this. I thought there was a Burgess involved here. Tough, smart, calculated. Woo. A general practice law firm. Attorney profile. Grit, small town values, and humble beginnings. Awesome. Oh, hey, at least he's licensed to practice in front of the Fifth Circuit Court of Appeals. That's probably pretty good. Find a lawyer. I want to, for the public, I want to find another lawyer. Do you need a lawyer? Find a lawyer. I like finding lawyers. I don't want you. I want name. Paste. Brandon J. Grable. Here we go. License since 2016. Okay. I mean, that's cool. He's been practicing longer than I have. Seems like an awful big one. I guess you can kind of tell the way this is shaping up here. Like, I don't know who this Burgess is, but I don't know what's going on here, actually. So Yeah, the Solomon Radner could be involved pro hac vice or something like that. I'm not entirely sure how they're involved in this. Um, they do get to amend their complaint once as a matter of right, so maybe they'll fix some of this stuff. Diet Pepsi. I'm going to call it Diet Coke, though, because my mom always drank Coke, so everything's a Coke. Have a Coke and a smile, even if it's a Pepsi. Diet Pepsi tastes better than Diet Coke. I said it. Sue me. I don't care. All right. Yeah, so the jurisdiction. So they don't start off with an introduction. That's kind of weird. Another thing that I think is kind of weird is normally you'd have like introduction would be section 1. Section 2 would be like jurisdiction and venue. Section 3 would be like parties, like Roman numeral 3. And then Roman numeral 4 would be statement of facts. Roman numeral 5 would be not meet the plaintiffs. That's weird. I'm not familiar with Meet the Plaintiffs. It sounds like a bad TV show. Would be the actual like incidents. So 5 and then number 1 would be count 1. And number 2 would be count 2. Although what's weird is calling them count 2. I don't know. It's not very strongly written. The repeat and reiterate part is pretty common. I see that a lot. See here they call him Plaintiff Springer, but they never set that up. It's just weird. It's just weird. So you know before you judge them, these attorneys too harshly, they're probably pretty new attorneys, and like I'm pretty good at writing, or at least I like to think I am. I tell myself, my mom says I'm very smart, but like you write it and then the next day you read it again and you're like, oh my God, I can't believe I did that. Oh, I missed that. Oh, that's the wrong word. Oh. And then you fix it and you're like, oh, this is amazing, right? Then you put it down and the next day you come back to it and you're like, oh my God, I can't believe I did this, and this. Oh, this sentence doesn't make sense anymore. Now I need to fix it. So you give them some slack, give them some slack. Yeah, I think it's weird. This section was really weird of the Mark Brown. If it was a detention occurred, he was arrested. Like, I don't know if you guys maybe did anything to research this. I don't know if you just talked to Mark Brown, because if you talked to him, I could understand why you'd be like confused as to what happened. But if you watch the video, you could be pretty sure an arrest happened. If you look, he's been arrested. So yeah, lots of fun stuff. Other weird things is they talk about Monell. So typically respondeat superior doesn't work for 1983 lawsuits. Respondeat superior means like the employer is responsible for the actions of the employee. Typically in tort law, the employee doesn't have a lot of money, so you want to go with the employer. So you try to prove that the employee was engaged in the employer's business when the alleged incident happened. So, like, yeah, the employee was driving his own vehicle, but he was actually going to the bank for the employer. So we're suing the employer under a theory of respondeat superior for the negligence of the employee. Monell liability is based on Monell v. Department of Social Services. And this is where the Supreme Court said, yes, you can sue government agencies like cities and things like that under 1983 if it's actually the policy of the city. So some of these things they will be able to show under Monell liability, but like excessive force, that wouldn't be a policy of the city. So they threw the kitchen sink at him. Like Leon Valley is a defendant in every single one of these things, whether or not Leon Valley was actually involved in it. Another thing that's weird is they bring up Manel liability and they don't actually put a citation into it or anything like that. Now, that's not super weird. In family law in California, there's Epstein credits and there's Watts credits and there's all sorts of other credits. Like there's a specific kind of credit. I forget the name of it right now, but there's a specific credit you can get if you go to prison. It has to do with prison credits, like knocking off your liability for family support. And I guess we don't technically in California. I've seen a lot of stuff referencing them, and I've never really seen a whole lot of links to them. So maybe that's what this is referring to. I'm not entirely sure. This is I've never done a 1983, a federal. I've never done anything federal, so this is kind of interesting. And yeah, the prayer for relief. I don't think they're going to get too far on the policies being unconstitutional. The full and fair compensatory damages. I don't know how well that's going to fly in front of a jury, because again, I know you guys don't want to believe this, but juries tend to be somewhat biased towards the police and biased against people who come to court wearing profanities on their t-shirt, unshaven, looking rough and gruff, etc. And just God help you if you get someone like Mark Brown on the stand. The defense attorney is just gonna rip him a new a-hole. He's not smart enough to be up there. Some of these guys like Jack would do fine up there. James, if he could avoid going all sob-sit, would do fine up there. But some of these guys just aren't the brightest bulbs. So I would hope to God they don't go up on the stand. Punitive damages. Remember, punitive damages are limited to about 10 times what the compensatory are. I don't think they're going to get a whole lot of compensatory damages. The Mark Brown thing's a loser. I know they're suing for it, but that doesn't mean a damn thing. The Mark Brown part's a loser. The Springer, as far as him being arrested is concerned, is probably a loser. He was arrested. He was charged. Did they get Bow in there? No, they didn't get Bow in there, but Springer's probably a loser. I think was it Howd was arrested. Somebody, Texas Wolfman, whichever one that was. I think he's gonna. I think it was Russell Zinter. Anyway, I think Texas Wolfman. I think his charge is going to go bye-bye. I don't think it's going to go very far. I'm not necessarily going to go as far as to say that that's going to be a winner, though. Just because your charges were dismissed doesn't automatically set you up for a 1983 lawsuit. But what they charged him under, that blocking a highway or entrance or something like that. I forget the exact name of it, but that seemed like a pretty bogus thing to do. I'm surprised that they even found probable cause on that. The seizing the property, I don't think that's going to win. The 30.06 is a pretty new thing that they're trying to use in a novel way. I don't think it's going to go terrible far as this is concerned. The detention of the witnesses, I think that's a bit of a question mark there. It may go well, it may not. I have some case law on that I might review later. This is weird. Oh, admission pending. Okay, so he's trying to come in pro hac vice. Okay. So, yeah. That's what I think about this. I don't think it's a huge winner, but who knows? Maybe. it's a possibility. Anyway, thank you for watching. Have a great day.